All right, everybody. This is Attorney Alexander Johnson. I'm a 33-year veteran landlord tenant attorney practicing in Broward County, Florida. And I'm going to go through the recently enacted Dade County Tenant Bill of Rights. This was passed May 3rd by unanimous vote of the Dade County Commission with an effective date of May 14th. So this is recent stuff. I don't think it got as much publicity as it warranted, because this is 20 pages of brand new landlord tenant law. This is the first in Florida that the counties have jumped in an area that's heretofore been completely regulated only by state law. So when a county decides to put a law on top of a state law, they only have the option to make things stricter. The county can't make state laws more lenient, only tougher. So this is laid on top of the regular state regulations that most of you are familiar with, is Florida Statutes Chapter 83, Part 2, residential. So this Dade County ordinance is limited to only Dade County, and it is limited to residential tenancies, not commercial, and also not things that are not considered residential tenancies, such as staying in a hospital, staying in a rehab center, being in jail, Airbnb, although it is possible for a hotel stay or a transient occupancy to turn into a tenancy with the passage of time. So the benchmark for when you turn into a transient into a tenant is 30 days. And that's based on the hotel ordinance. It states once you've been in a hotel for 30 days, you're not a guest anymore, you're a tenant. So if you're doing Airbnbs, keep that in mind, that they may start off as a tenant, but if you keep extending the stay, once 30 days has rolled by, you've got a tenant, which means they get all the protections of Chapter 83. And if you're in Dade, this Tenant Bill of Rights. So what are the rights? So again, this is only residential tenancies and only people that are covered by Chapter 83. So that's not trespassers, that's not guests, that's not transients. But it could be that those people that started off as non-tenants can turn into tenants. And this was enacted because of the rent increases, which were reported as being as much as 40% on average. And the fact that tenants under state law were only entitled to 15 days notice to terminate their month-to-month tenancy or for a rent increase. So step one for Dade was to change that 15-day period to 60 days. So now to raise the rent more than 5% or to terminate a month-to-month tenancy, you now must get written notice no less than 60 days before the end of your monthly rental period. So while it's typical that your month is a calendar month, like from May 1 to May 31, it's not always the case. The month can be from the 15th, or it can be the day you move in. So if you moved in on May 26th, it could be your month is from the 26th to the 26th. But the 60 days is 60 days before your rollover day. So if I moved in May 26th, then I could terminate you May 26th, June 26th, July 26th. But if you moved in May 1 and each month is a calendar month, then if I gave you a notice in May, it's not going to take effect until the end of 2 more months. So that's June, July, July 30th, July 31. So it's not just 60 days from the notice, it's a minimum of 60 days before your anniversary date. So whatever your anniversary date, that's always going to be the date that your tenancy ends. You can't make up a new date. So that 60-day notice of rent increase or termination is no less than 60 days before your rollover date. So just think of it, whenever you give the notice, it's going to be 2 extra months on top of that. So that does require some planning. So that was the big one. And Broward jumped in on that, and they also enacted the 60-day rule for non-renewals and rent increases. So that is now the case in Broward and Dade. Nowhere else so far. Also with this Tenant Bill of Rights, it passed in Dade, but Broward seems to be hot on Dade's heels. In the last monthly commission meeting, Dade or Broward authorized the city attorney to draft up a Broward Tenant Bill of Rights. So I wouldn't be surprised to see something very similar enacted within the next month or two here in Broward. And granted that Dade passed this unanimously, I would say that the sympathies are similar in Broward. In fact, Broward's County Commission is even more liberal than Dade. So it's just a heads up that if this takes place, it could happen as early as June. And then we'll do questions at the end, just so I can get through it. I know Maritza wants me to keep in schedule. We've only got 10 minutes. So again, this is restricted to residential. So what are some of the major provisions of this law? So the first is they declared a series of things to be unlawful. So what is now unlawful? One is terminating the utilities or interrupting the utilities. And that is whether or not it's under the control of the landlord. But if the landlord causes the utilities to be interrupted, it's a violation of the Tenant Bill of Rights. So you have to, one of the other parts of the Tenant Bill of Rights is a violation of this ordinance is enforceable by a lawsuit with attorney's fees. So under Chapter 83, the landlord-tenant statute, attorney's fees may be awarded, but in this ordinance, attorney's fees shall be awarded. So that is different. Under Chapter 83, the only shall be awarded is for security deposit cases. And that's important because frequently in litigation, the attorney's fees is the biggest point of controversy. So as an example, I've had lawsuits on behalf of tenants against the landlord to get their attorney's fees or their security deposit back. And the attorney's fees have been maybe 400% more money than the deposit. So that becomes what the lawsuit is all about. So landlords are going to have to be very cautious that they don't get a violation of the Tenant Bill of Rights, which results in a lawsuit, which results in mandatory attorney's fees. Because we're talking, $2, $6, $8, $10,000. That's a big deal. So interrupting utilities, illegal. The next is collecting rent when you're delinquent on your condo dues. So as you remember, during the big bursting of the real estate bubble in 2008, one of the big problems was that these condo owners stopped paying their mortgages and they stopped paying their dues, but they were renting out the unit and collecting rent. So the condos were really upset because no one was paying the dues. There's nothing they could do about it because if they foreclosed, then the bank is going to foreclose and wipe them out. So they're like, well, our hands are tied because it's pointless to foreclose when the bank is going to come on your heels and foreclose you. So they couldn't collect any dues and it was a real crisis. So they passed a law that said that when the unit owner is delinquent on paying their dues, that the condo can send a demand to the tenant and say, tenant, we're seizing the rent money. Now you pay the rent to us. And that can continue as long as the dues are in arrears. So they can seize the rent. So in the Tenant Bill of Rights that just passed, they said that if that has happened, that the unit owner is delinquent in their dues and the condo has seized the dues, that it is now a violation for the landlord of the unit owner to evict that tenant for non-payment of rent, or even threaten to evict the tenant for non-payment of rent. So that is something that has never happened before. Is even the threat of an eviction is illegal. right? The other radical thing in the Tenant Bill of Rights is a provision that allows the tenant to repair and deduct. Under state law, if the landlord's not maintaining the unit, and the statute states that the landlord is required to keep the property up to code and essentially to maintain the property in the condition that it was in when the tenancy started, that if the landlord's not doing that, that the tenant was allowed to give the landlord a 7-day notice to do the repairs. And once the 7-day notice issued, if the landlord didn't make a reasonable effort to complete the repairs, the tenant was authorized to do one of two things. One, to go on rent strike until the repairs got done, or two, if the property was not habitable, to declare the lease in breach and vacate the premises. So with the Tenant Bill of Rights, they added a third remedy. So as a third option, the tenant is now entitled, after they gave the 7-day notice, to do the repairs themselves and deduct the cost from the rent. That was prohibited outside of the Tenant Bill of Rights. So now, after the 7 days, the tenant can then hire their own contractor. The Bill of Rights requires them to get at least 2 bids from licensed contractors. Then they hire the licensed contractor, pay them out of the rent for the work. They have to have receipts for the work done. They need to document the condition before and after, and then they can deduct that from the rent. And if the landlord evicts them for not paying the rent, that is a violation of the Tenant Bill of Rights. So that is a big change, because now the landlord is facing attorney's fees. But what are you going to do? The tenant's not paying rent anymore. They're spending the rent money on repairs. So before, what would happen is the tenant would stop paying rent, and then the landlord would give them a 3-day notice and file an eviction. Then the court would have a rent determination hearing, decide how bad the conditions were, and if they were bad, the judge would reduce the rent until the place was fixed. But in that type of litigation, the judge rarely awarded attorney's fees. But with the Tenant Bill of Rights, I think that the tenant is much more likely to recover their attorney's fees than under the state statute. So I can see a lot of litigation coming from this repair and deduct thing, because a lot of the calls I get from tenants are for big items like the air conditioning, the central air, or mold remediation. So we're talking about $5,000, $10,000 repair items. So that's a big deal if all of a sudden the tenant decides that they're going to do a $10,000 repair job and not pay rent. So, keep an eye on it. Another thing that's new and a little bit scary for landlords is that, and I think this is from the Surfside collapse, that this part of the statute states that if the building department has declared a property unsafe, and that condition can be attributed to the willful or negligent act of the landlord, then the landlord is required to, within 8 hours, to rehouse all of their tenants and pay for their living conditions and moving expenses for 3 months. So imagine if you were the owner of Surfside and you had 100 tenants, and it's your fault the building's not safe. You got to put all 100 of your tenants in another place, pay their rent for 3 months, and pay their moving expenses. And then also everything that's a violation of the ordinance is attorney's fees. So this is some scary stuff for landlords. Another part of the statute is that they broadened the definition of discrimination. So I'll just read it, because now a lot of things are discrimination that you might have thought about. So here's the list. Now, all of these things are discrimination: race, color, religion, ancestry, national origin, sex, pregnancy, age, disability, marital status, familial status, gender identity, gender expression, sexual orientation, actual or perceived status as a victim of domestic violence, dating violence, stalking, or source of income. So what does source of income mean? What it means is if you're getting rental assistance. So if the tenant has a Section 8 voucher, you can't turn them down because they get assistance. Or another thing that comes up is with the pandemic is our Florida has been giving rental assistance on a temporary basis. So to turn someone down or kick them out because they're getting assistance is now illegal. Broward passed an ordinance a couple of years ago that also defined source of income as discrimination. And immediately, this law firm from Washington flew into town and filed 200 lawsuits against realtors that had listings that said no Section 8. So we all know that a lot of condos don't like people in their building that are on assistance. So the realtor would just acknowledge the condo's desire not to have people on assistance, and they put in the listing no Section 8. So boom, they all got sued. And these lawyers were looking for $5,000 a pop for these suits. So
May I ask a question about that?
sure. Well, let me hold the questions because I want to get through the meat of it before, and it's one already, but then we'll do Q&A.
No problem.
All right. What else do we have? If you get a notice as a landlord that your building is unsafe, you have to notify the tenant within 14 days. If you're planning on selling the property, you must give the tenant notice of change of ownership either 60 days beforehand or simultaneously with the change of ownership. But now the tenant is entitled to a notice of change of ownership. Additionally, a new requirement is that you can't ask the tenant, a prospective tenant, their eviction history until after you've qualified them on all other grounds. So they don't have to tell you whether they've been evicted before until they've gone through all the other background checks. So you've checked their credit, you've run their history, their criminal, and at the very end of all that, then you can ask if they've been evicted before. The ordinance sets up a helpline. So this is a number that the tenant can call to ask for advice. And here's the deal about the helpline. If a tenant calls the helpline and the landlord evicts or threatens to evict the tenant, within 60 days of them calling the helpline, it's lawfully presumed the landlord's discriminating. So before, there was in Chapter 83 a provision that says you can't discriminate, and you can't discriminate for upholding your own rights. But the burden was on the tenant to prove the discrimination, and that was tricky to do. But now they've turned it around and say that it's presumed the landlord's discriminating. So now the landlord is guilty until proven innocent. So it's exactly the reverse of the way it was before. So another thing to be worried about. And part of that is what is also illegal: to retaliate, coerce, intimidate, threaten, harass the tenant or anyone helping the tenant. So not just filing an eviction, but threatening an eviction, talking about an eviction, or even anything that's threatening or intimidating to a friend of the tenant that's helping them out, against the law. The Tenant Bill of Rights, the landlord's required to give the tenant a copy of the Bill of Rights within 10 days of the beginning of a tenancy or the renewal of a tenancy. The tenant is supposed to sign a receipt that they've received it, and the landlord has to keep a record of that for at least 60 days after the end of the tenancy. And the newly created Office of Housing Advocacy can then ask the landlord for their records to make sure that they gave those notices. So Dade has created a new agency, the Office of Housing Advocacy, They started off with a budget of $835,000, which is, I think, 4 employees. And then they have the helpline and a website. So now there's like a little bureaucracy that's going to help out. And then another thing, which I think is going to be trouble for landlords, is they created the right of private enforcement. So it's like your own attorney general, that the tenant can file a lawsuit for a violation of the ordinance within 2 years of the violation. So there's a 2-year statute of limitation, but they can then sue the landlord. And then here are the remedies: injunctive relief, equitable relief, money damages, attorney's fees, interest, and costs. So this is new. And again, by putting in attorney's fees, it's sort of, well, I've been accused of the lawsuits I do against landlords is they either call it extortion or a license to steal, but it's definitely going to attract the interest of attorneys to file suits to get fees on all these violations. So I can see trouble for landlords. So that is the gist of the new Tenant Bill of Rights. If you go to my website, browardlandlord.com, or my blog, Florida Landlord Tenant blog, you can get a copy of the Bill of Rights. Dade was supposed to put it on their website, but they haven't. But you're still required to give it to the tenant. So you might want to download it. You just print out the ordinance and hand it to the tenant. So this is law in Dade as of 2 weeks ago. And probably it's going to be law in Broward pretty soon. So now I will take your questions. So just go ahead and unmute yourself and ask whatever questions you'd like.
So I was curious on the Section 8 and denying people based on Section 8. I was under the impression that you need to have your property approved to do Section 8 in order to rent to Section 8. Is that incorrect?
That is true. That you have to be inspected and approved. But where people were getting in trouble is they would have a listing that says no Section 8. So boom, just by saying that, you violated the law. And then the attorney
Right.
comes from Washington and sues you and wants $5,000.
Okay.
You know who they were suing? The realtors. So anyone who says no Section 8 is breaking the law.
Okay.
Yeah,
And then
source of income is the protected class in Miami-Dade and Broward, and now up in Hillsborough County, where Tampa is.
Did you say source of revenue is also in Hillsborough?
Yeah, that was last year. That's the recent one up there as well.
Right. So that's making it tricky for landlords when all the counties, we've got 67 counties, when they all start passing their own rules, it's going to be hard to keep up with. But
I know people who only rent to Section 8 people because their properties, qualified for Section 8. So how do you handle something like this if you're got this Bill of Rights and can't ask about Section 8?
well, it's not you can't ask about it, you can't discriminate. So the most blatant form of discrimination is to put it in your listing. But if the tenant can prove, and it's not just the tenant, because HUD has approved stalking horses. So you can actually, so when I said that law firm came and sued 200 realtors in Broward when they passed the source of income ordinance, it was the same applicant. That guy wasn't looking to rent in those 200 places. So they can just get a straw person. And once they see your ad, no Section 8, that person can file the suit because the discrimination was in turning them down, not the fact they were an actual applicant. But I agree, I like Section 8, but frankly, when those condos say they don't like Section 8, we all know what they're really doing is they're discriminating on other basis. So that was sort of a code to maybe discriminate on the basis of race. But normally,
I put a bunch of questions in the chat just for your information.
all right, it'd be easier for me if you just give me your question verbally. So I don't have to jump back and forth into the chat. Anyone else?
No, I was just for later.
Okay, thanks. Yeah,
Call me.
feel free to email me with the question or call me if you're a landlord. We've got an issue coming up. I'm always happy to help out anyone from the group. Dave Baumel, you have your
Alex?
hand up, but I don't see you in the
Oops.
screen. Yeah, Sandra, go ahead.
Alex, can property owners advertise to get Section 8 people if their property has been approved and say Section 8 applicants welcome?
Yes.
Okay.
Unwelcome, no. Welcome, yes.
Oh, just not the word welcome. Section 8 available, Section 8 approved, Section 8.
You
I mean,
can-
what would somebody say?
You can say
I don't think
welcome.
you should mention it at all, in my opinion, because it is a protected class like anything else. You don't mention it. It shouldn't be mentioned at all.
Well, how can a Section 8 person find housing for Section 8? I don't, that's not a lane that I'm familiar with.
Yeah, no, that's the point. It's anywhere that is available for rent is available for rent to anybody, regardless of the source of income. Nobody can tell you cannot rent if you are using a housing voucher of any sort.
But I
So
thought
once
Hannah
it's
said
available
that
for
properties have to be approved by Section 8 for the government to see that the property
Yeah, but that
has
happens
criteria.
after. No, but that happens after the tenant is approved. It's not something they do in advance. They have to have someone there that's taking, this is not just, everybody says Section 8, this is any sort of housing authority, whether it's private or public. The process is the applicant goes through the process to be to be approved like any other tenant. If they are approved because of everything in their history and so forth, all the documentation is then sent to the housing authority, whoever they are. They then send out someone to check on the property to make sure that it's approved. And then that's how the approval process goes. It does not happen in advance. I actually asked this question because I was on a landlord workshop in Broward and I asked, can I get my properties approved in advance? And they said, no, you have to actually have someone ready to move in for the process to go through.
Well, that's really wacky because if you've got to go out hunting for a place and then apply for it, I mean, it seems like that's ass backwards, you know, and forgive my ignorance, but
No, I agree with you, but that's how it is.
Right.
leave it to the housing authority.
That's a very good point, Marissa, because merely saying the word of a protected class is a violation. So now that source of income is a protected class, you're right. Just saying the word, you've already violated the ordinance.
I'm really confused here because Section 8 is a national program. And in the Washington, D.C. area, there's a guy, Dr. Joe Asamoah, who has been for like 40 years successfully using Section 8. And there's a limit as to what you can pay under Section 8. He actually is one of the few people they pay more for his properties. They're so nice the way he fixes them up. But the whole marketing model says, you know, basically Section 8 pays, you hope 100% or some amount. So you are always going to get paid. You don't have to worry about evicting or anything else like that. And the Section 8 gives you leverage because it takes forever to get in the program. And if they don't do it right, they're kicked out of the program. So they're a very stable tenant. They take care of the property. If not, Section 8 makes sure it's fixed. You know, all these bad things that can happen to a landlord won't happen if you go to a Section 8 tenant and the rent's a little lower, but they're steady tenants. So you have less vacancy. So that whole model would collapse if you have to just do generic advertising and not say this is a Section 8 rental and all the other things. So it's kind of interesting.
So does that mean that for every time you have a new Section 8 tenant, you'd have to get the same property reapproved?
No,